As we all know, the government is now placing cases that were administratively closed back on the active docket. And so I've gotten a lot of questions lately about what the difference is between administrative closure, termination, and dismissal of your case. And so I want to take a minute to explain what is happening and who is at risk of being placed back on the docket and what the differences are. Okay? So, administrative closure essentially means that the government, who is prosecuting you in deportation proceedings, has taken discretionary action to remove your case from the active docket. Your case remains open but inactive for various reasons. Usually it's in the interest of judicial economy. You have pending relief available to you. Maybe you're a TPS recipient. You're in the process of something else with USCIS. And instead of moving forward with the prosecution of the deportation, they say, we are going to take this off the active docket. It doesn't make sense to use resources to prosecute this. We're going to essentially wait it out, and later you can probably file a motion to terminate if you're granted X, Y, or Z relief, or it'll just be administratively closed indefinitely. These are the cases that are now being placed back on the active docket. Usually, if your case is administratively closed, it's because DHS, the government, decided to do it, not necessarily the immigration judge, okay? Sometimes it's the immigration judge, but usually it's the prosecutor, it's OPLA, okay, the ICE attorneys. Now, what they're doing is they're saying, we are not giving these people who have been in administrative closure the benefit of the doubt anymore. We are placing them back on active docket, and we are prosecuting them for removal. In other words, they need to defend their deportation, show us why they should be eligible to remain in the United States. Okay, that is administrative closure. Now, termination and dismissal are often used interchangeably. However, they're similar but not the same. Termination is usually done by a judge. So a judge will terminate your case, but your case is closed at that point. It's a final decision on the case, and if the government wanted to oppose termination, they would essentially have to file an appeal with DHS, okay? With the BIA, I'm sorry. Now, dismissal is like in a criminal case. They have dismissed the charges against you. They've dismissed the immigration proceedings against you. In this case, the case is also closed. But like in a criminal case, they could bring the charges again. They could issue a new NTA and prosecute you for removal or deportation. So dismissal is done by OPLA or the ICE attorneys, termination by the judge. Termination, in both situations, the cases are closed. Termination is a final order that would be appealed to the BIA. Dismissal, though, is the government deciding not to prosecute you, essentially dropping the charges. But it doesn't mean that they couldn't bring the charges. However, unlike administrative closure, it would be like refiling. It's not that your case has remained open this whole time. So I hope that this clarifies those three for you. And if your case has been administratively closed, then you are in the group of people that should probably seek counsel to talk about a strategy for the defense of your removal if in fact you do get a notice that it has been placed back on the active docket.